and welcome to another talk in our research seminar series. It's my pleasure to introduce our speaker today, Dr. Magdalena Szczerbak of Jagiellonian University and the University of Pardubice as well. Magdalena is a graduate of Jagiellonian University, which, as some of you probably know, is one of the oldest universities in the world. And she has qualifications in both linguistics and law. She has published widely on language and law, including a monograph on concession in the discourse of judges. More recently, she's been interested in stance and evaluation in courtroom discourse. And today she's going to talk to us about interactional management of knowledge claims in expert testimony. So Magdalena, thank you for accepting our invitation. And welcome to the Aston Institute for Forensic Linguistics. The floor is yours.
All right. Well, thank you very much for this generous introduction. I must admit, I'm terrified. I mean, I'm happy to be here, but it's my first time here, and I'm kind of stressed. But I do hope the stress will go away. Right. Just in case there were some unforeseeable technical problems, I have pre-recorded my talk, and I'm going to play it to you right now. But then, of course, I'll be happy to talk to you afterwards, and I hope that's acceptable for everyone. I just hope it's gonna work. Is my screen showing at your end?
Yes, we can see it.
Mm-hmm. All right, so here we go.
Magda, I don't think it's worked now. The screen went off.
All right, I'll try again if you let me.
Sure.
Yeah, we can see your slides again now.
Good.
Hello, everyone.
Yeah, that's
Welcome
fine.
to my talk. It gives me a great pleasure to be able to talk to you today, and thank you for having me here. So, today we'll be looking at some of the ways in which participants in jury trials communicate their knowledge, some of the ways in which they negotiate the status of this knowledge, or in other words, the ways in which they orient themselves to the epistemic domain. Well, first, let me say a few words about my background, just to let you know where I come from and what the focus of my research is. So, what I'm interested in is epistemological positioning in legal genres, and in particular in judicial opinions and in courtroom talk. And recently, I've been working with criminal trial data representing jury trials with expert witnesses, acting within the constraints of the Anglo-American legal system, the adversarial procedure. And I'm looking at the intersection of language and science. I'm looking at the ways in which knowledge is communicated, both linguistically and multimodally. And I'm looking at the strategies which are relevant to how knowledge is communicated and how the status of this knowledge is negotiated, how it's turned into evidence. Well, today I'll be looking specifically at a subset of stance markers. To be more specific, those involving the pronouns I, you, and we. And these have been categorized as explicit, personal, and shared responsibility markers. So I'll be looking at their relevance in a context of expert testimony. So what I'm gonna do first is give you a brief introduction to some of the linguistic notions which are relevant to my analysis and would show you the perspective from which I approach core term data. And I'm going to unpack these notions for you. And then we'll move on to the core term context, and I'm going to share with you some of the examples which I analyze in my study. Here we go. Well, I know it seems like an obvious thing to say, but I'm going to say it anyway. Whenever we impart some information, whenever we engage in transactional discourse, we also betray our perspective. We share our point of view. We communicate our attitude. We make value judgments. We make assessments. In other words, we communicate our stance. What's more, speakers qualify in some way the information which they communicate. They either mark their personal responsibility for the validity of the information, or they refer to some shared knowledge. They communicate shared responsibility for the information. And depending on what markers they rely on, they show the audience how they want this information to be interpreted, how they want it to be interpreted in the context of the ongoing interaction. Now, related to linguistic subjectivity are two other notions, that of epistemic stance and that of evidentiality. And these two notions will be especially relevant in the context of my study. So as to epistemic stance, it refers to our knowledge or belief vis-a-vis some focus of concern. It describes various degrees of certainty. It communicates various degrees of a speaker's commitment to the truth of the proposition they're communicating. It refers to different sources of knowledge. As for evidentiality, two positions are found in the literature. In a narrow sense, in a narrow approach, it describes only the grammatical, morphological marking of information source. It doesn't apply to English. Or in a broader approach, evidentiality describes various ways in which information source is marked. It refers to grammatical markers, lexical markers, or other means which mark information source, but at the same time, they are indicative of the reliability of the information. And that's the approach which I follow in my analysis as well. All right, so we have linguistic subjectivity, epistemic stance, evidentiality, and now this brings us to a broader notion, this overarching term, which is stance. And now I put these pictures here just to help you realize that stance, that our attitude is something which is marked in a multimodal manner. So our thoughts, our intents, they become visible, or they are expressed through our linguistic behavior and our non-linguistic behavior. Well, I won't be able to describe both levels of expression in today's analysis, yeah, but this is just to make you realize that whenever we communicate our attitudes, whenever we communicate our stances, it's done through our multimodal conduct. And this is especially relevant in a courtroom when you think about the way in which an expert witness's testimony or their presentational style is assessed by the jurors. What does matter is not only the scientific knowledge they communicate, but also the manner in which they communicate. They bring this idea to the audience, that is the jury. And now, well, actually, as for this multimodal expression of stance, this is what I'm doing here as well today. I think it is important for the audience to be able to see the speaker, not just the written words, yeah, because a lot of meaning is lost. It is a bit challenging for me right now, yeah, because talking to you here and sitting in front of my computer. But anyway, I think it is important for the audience to be able to see the speaker, to be able to see their body language, to be able to see their involvement, yeah? And all these factors, they do play a role in a courtroom as well. Right. Now, when you think about how knowledge claims are managed in a dialogue, in interaction, there is vast scholarship dealing with this issue, dealing with epistemics. There are numerous conversation analytic studies addressing this area in particular. I'm not going to discuss them here in detail, but this is just to bring to your attention some of the notions which are especially relevant in these studies. And by this, I mean not just epistemic stance, but also epistemic status and epistemic authority. And this is what's happening in a courtroom again, where you have speakers who handle their rights, who manage their rights to talk about certain topics, to discuss some issues from different domains of knowledge. Yeah, so they negotiate their authority, their epistemic authority. Right. Another thing which I would like to bring to your attention, and which is also relevant in the context of this analysis, which I'm going to present later on, is what we call speaker commitment. Interestingly, total commitment to the truth of the propositions we communicate is often zero marked. We have plain declaratives. In our culture models, in our culture scripts, information is assumed to be true unless otherwise indicated, unless otherwise qualified. And therefore, this total commitment, which is zero marked, as I said, is not amenable to automated analysis. Yeah, it's challenging to find it in this course if you use corpus analysis, for instance. However, that is not to say that speakers or writers do not mark their stances explicitly, because they do. And now the model which I have adopted in my study is what you can see here on this slide, where you have three types of stances, or three types of information source, or three types of access to information. The first category of markers describes these markers which signal the speaker's evidential stance when they refer to things which they have personally experienced, which they saw, which they heard. So this is evidential stance. The second category is that of cognitive markers or mental markers. Here, the speaker refers to his or her internal frame of reference. Their knowledge is based on their cognitive processes. And finally, the third type of stance, communicative stance, where speakers make meta comments, where they refer to their own talk, or where they recycle prior discourse. It's talk about the talk. It's reusing, reframing, recontextualizing earlier talk. And again, in the context of the courtroom, this would be prior testimony. So I'll be referring to these three types of markers: experiential, cognitive, and communicative. At this point, it may be hypothesized that in the case of expert witnesses, cognitive stance markers will play a role. In a case of lay witnesses, you would expect to find a greater accumulation of experiential stance markers, given that lay witnesses are allowed to talk only about what they have personally observed or experienced, and they're not allowed to offer their opinions. But we'll come to that later on. Right. As regards varying degrees of speaker commitment, these are inevitably linked to the type of marking. And what you can see here are four categories of markers, which are related either to explicit or implicit responsibility for the information shared by the speaker. And later on, I'll be zooming in on the first two categories involving personal pronouns. So these are explicit responsibility markers. Right. It's time for us to move on to the courtroom context. Since I'll be looking at expert testimony, it seems a reasonable thing to explain who an expert witness is. I mean, we all have this commonsensical understanding of an expert as someone having specialized knowledge in a certain domain. But from a legal point of view, an expert witness is someone who is recognized as having this special knowledge, someone having special competence, right? To special competence to draw inferences from evidence, someone having access to a large body of evidence from a given domain, someone being able to reason about this special evidence. Now, as to the admissibility criteria, there are some principles, there are some standards which are in place as regards expert testimony in the Anglo-American legal context. I'm not going to talk about history and the evolution of these principles and Frye and Dover. What I would like to draw attention to is Rule 702, which in a way codifies these earlier principles. And what it says is that a witness is someone who is qualified as an expert, is someone who is allowed to offer testimony in the form of an opinion if they have specialized knowledge, if they have a right skill, experience, training, or education. And an expert witness's role is facilitative. An expert witness is to assist the jury in reaching conclusions. And a kind of knowledge which is communicated by expert witnesses needs to go beyond the ken of an average juror. Otherwise, it's not considered to be necessary. Otherwise, it's superfluous. All right, so an expert witness is allowed to offer their opinion. They need to communicate their knowledge with a reasonable degree of scientific or discipline certainty. They need to apply certain principles and methods. They need to abide by industry standards, and they need to apply the rules reliably. Now, when you look at the linguistic behavior of expert witnesses, and this is what we're interested in here, it is a result of this larger context, and this is what we're going to look at in a moment. Right, now let us move on to the data which I use in my study. Right, so in my study, I used transcripts from the Westerfield trial. It was a criminal trial of a defendant was found guilty of first-degree murder, kidnapping, and possession of child pornography. Crucial in this case, what was crucial in this case was expert evidence, and the evidence was provided by forensic entomologists, anthropologists, and computer specialists. I used 4 days of testimony provided by 3 entomologists, 1 anthropologist, all of whom were called by the defense. And I consider this amount of data to be sufficient for my purposes, that is in this preliminary analysis of stance-taking practices in expert discourse. In the study, I adopted a corpus-driven approach. That is, I started my exploration with the 3 pronouns I, you, and we, which are associated with explicit responsibility for the information which speakers communicate. And I looked at the clusters, 3-word clusters in which these pronouns were found. So actually, I regarded these as access points, right? As points of departure for a contextual analysis of the patterns which proved to be the most frequent ones. And as I said earlier, in this particular study, I focus only on a small group of markers, just to see what linguistic resources the speakers mobilize in order to negotiate the status of a knowledge which they conveyed during testimony. Right. So this is what the analysis showed. What you can see here are the most frequent patterns, the most frequent three-word clusters associated with the three pronouns, and I don't prove to be the most frequent of them all. I don't provide the figures here. I don't think they are relevant because I'm going to look at the context in which these were found, but this gives you some idea about the kind of stances associated with the markers. As for the pronoun I, negation is visible here, yeah, and disclaiming knowledge, and we will see this later on. As for patterns associated with the pronoun you, you see the verb told here, which again signals communicative stance and referring to prior discourse. And as for we, what we see here are references or words which are used to create a joint object of attention, saying we have this, or we look at that, or we're talking about this or that. But again, I'll show these in context. As for I clusters, again, I don't know, I don't think, I don't believe, and that I'm not really sure. I'm not a botanist. I'm not saying these were three groups of markers which turn out to be the most visible ones, the most frequently used ones. Before again we look at the examples, just a few words about I don't know responses. I don't know, I don't recall, I cannot remember. These are regarded as, or these reflect the stance of detachment or non-commitment or apathy, if you like this terminology. So in other words, by using these, speakers actually refrain from assigning any validity to the information. They opt out. They signal non-commitment, and this is especially relevant in adversarial interaction, where these responses resist something about the question, and the disclaiming of knowledge enables witnesses to construct neutral ground or to adopt a posture of innocence. Put differently, the disclaiming of knowledge circumvents the consequences of saying yes or no or committing to either answer. Well, I don't know performs a number of functions in different types of discourse. I put several references here if you're interested in how it's deployed in political discourse or in medical discourse. So it's not just about disclaiming knowledge. That's the literal meaning of I don't know. But apart from the literal meaning, there are a number of interactional uses, and they're listed here. I don't know is used to avoid assessment, to preface disagreement, to avoid explicit disagreement, to avoid explicit commitment, to minimize impolite beliefs, or to indicate uncertainty. Not all of these resurface in my data, but as you will see in the examples which will follow, I don't know. There's more to I don't know than just claiming no knowledge. Yeah. It's more than just a disclaimer of knowledge. Okay, so what I'm gonna do now is run through the examples which I have prepared here. I'm not going to read everything here. You may want to play back the presentation later on if you want to, but I just would like to bring to your attention some of the functions which I found when examining the data and when looking at selected markers and context. So what you can see here is standalone I don't know, which is a literal disclaimer of knowledge. And yeah, and if you want a bit of a context here, so you have a cross-examining attorney and an entomologist discussing some of the estimates, and they're talking about trying to estimate the time of death, and trying to consider the conditions in which the body was found. And the witness says, I don't know, it's unqualified, and it marks their lack of knowledge. What you can see here in this example is I don't know, which is followed by kind of justification, and a witness provides a reason for not knowing. Yeah, so that's another pattern which I found with I don't know. I don't know was followed by some kind of qualification. There is a question which refers to the kind of knowledge that the expert witness does not have because it's not part of their expertise. And they say, I don't know, I'm not a radiologist. Yeah, so their lack of knowledge and then the reason for not knowing is provided. All right, the third pattern that I discovered was when I don't know was followed by a candidate answer. And in this pattern, the speaker marked lower certainty. It's not that they didn't know the answer, but they were not sure about the exact answer. And here are the attorneys asking about the time the witness spent, the time they put in on a case, and the witness is not quite sure how much time they devoted to the case, and he started by saying I don't know, but then offers a kind of answer, which is again kind of an approximation, really. Here comes pattern number 4, where I don't know was used to mark limited knowledge, or it was used in a context where some kind of limitation was provided. And again, they were discussing the body, the child's body, and the state in which it was, trying to estimate the time of death, and discussing maggot activity and the reproductive cycle. And again, the attorney is asking a specific question about a specific condition, talking about bleach in this particular case, and then the witness says, oh, as far as the bleach affecting, I don't know. And I don't know is used turn finally. So in this case, it's in a context where the witness talks about the limited knowledge, and they don't want to commit, he does not want to commit himself fully to the answer provided. The last pattern in which I don't know was found in my data, the 6th pattern, was when I don't know was used as a discourse marker. And this is what you can see here, where I don't know, it was probably under stress. I mean, I have no information about prosody, but I can presume it wasn't stressed here. And they're talking about one document. Well, the attorney is asking a question about the document and then trying to find the right word. Yeah, I like to show you a document, just ask you whether or not this is I don't know, your curriculum vitae, your resume. Oh yes, sir, that's a copy of mine, etc. So you just have this this sample here of different uses of I don't know, but what it shows that it is that I don't know is used in different contexts, and it is not used just to mark the speaker's lack of knowledge. It performs a number of pragmatic functions, and these should be considered when a witness stance is assessed. Now, moving on to I don't think type responses, they differ from I don't know responses. So negative polarity statements with belief verbs like I don't think or I don't believe, these were found in contexts where there was some kind of disagreement, right? These were linked to a kind of a negotiation of how reality was to be interpreted by the interactants. When you compare I don't think, that is a negative declarative, with affirmative declaratives, they are explicated differently. They are related to different speech acts. With affirmative declaratives, these can be explicated as the speaker knows P and the hearer does not know P. As for negative declaratives, these can be explicated as the hearer wrongly believes in P and the speaker knows better. And to make it clearer, please consider the following examples, which illustrate contexts where the witnesses were trying to resist some knowledge claims which were being attributed to them. And here again, you have a counsel saying, oh, did you have specific disagreements with it in particular specific areas? I don't think I would term it as specific disagreement. So they disagree with the label, with the terminology used by the attorney. So it shows a kind of resistance, right, on the part of the witness. They don't agree with the terminology or with the claim that's being attributed to them by the attorney. And here I have a similar, where I have a similar case, a similar pattern. And again, they are reconsidering some of the calculations made by different entomologists. And they're talking about maggot activity on the body again. And then the last question is, oh, is that your testimony? And the attorneys referring specifically or mentions 5 days, and then the witness says, I don't believe I used 5 days. What did you? Oh, I said several days. So this kind of correction follows. Yeah. So I don't believe were used to mark resistance, to show disagreements with the attorney. As for I'm not type knowledge disclaimers, these fall into two groups, those linked to non-commitment or FNA, and those linked to lower certainty. So please consider the following examples which illustrate such uses. Here we have I'm not aware response, and again, the witness shows non-commitment. They don't want to commit to any version, to any specific answer to the question asked by the attorney. Another pattern with lower certainty. I'm not really sure. I'm not 100% sure. I'm not exactly sure. In such context, as is clear, the witness marked lower certainty. In this example, as you can see, the expert provides the reason for not knowing the answer. So they would say things like, I'm not a specialist I'm not a radiologist, I'm not a botanist. So they disclaimed having a specific kind of expert knowledge related to the domain, which was not part of their expertise. In this subgroup of markers, communication verbs were also visible. And here we have an example of an expert witness saying, using the progressive form of the verb tell and saying, oh, I'm not telling you that, I'm telling you something different. And there were other similar examples with, I'm not saying. So these were used again to show resistance to the knowledge, or to the knowledge claim which was being attributed to them by the attorney. Well, I'm not sure if you're still following my talk, but if you are listening, please bear with me for a little while, and I'm going to show you a few more examples before reaching some conclusions. So what we're looking at here are types of questions which were most frequently associated with the pronoun you. And these were found, as could be expected, in the attorney's turns, where they refer to the witness's earlier testimony. And basically, the goal was to undermine their earlier testimony. So let's have a look at the examples and contexts of use. You told us that there was by far the most frequent structure, and again, it was used to polarize the audience, to present some kind of information for the benefit of the jury. Yeah, it's us against you. This is what you told us. Is that right? This is what you the kind of information you provided earlier. Would you confirm it now? So these were confirmation-seeking questions. What was interesting for me in this reporting structure was the use of the phrase "I think," which I think does not surprise you when you're a native speaker of English, but when you're not, and when you think about other languages, and here I'm referring to Polish, which is my mother tongue, and then this "I think" part would be absent here when you think about a similar context in a Polish courtroom where well, Polish speakers tend to make more categorical statements. So prefacing "you told us" with "I think" seems to be part of this Anglo-American script here, where more distancing is conveyed. But this is just a digression. Right, didn't you? Was another cluster which was among the top 5 clusters associated with you. And again, these questions were found in the questions which were intended to challenge the witness's testimony. And there was, and actually these tag questions here, they clustered together. There were more of them, and the purpose behind the series of questions was to challenge the witness's testimony, basically. As for weak clusters, these were the most frequent co-occurrences. We don't have, we have, we look, we're talking, and if we have. And here we reach the point where I can say something about hypotheticals, which I think are a fascinating thing to explore, especially in a legal context. But worth noting here are references to external frames of reference, so referring to or creating objects of joint attention, referring to the kind of information which is accessible to all discourse participants. And again, I hope this will become visible in examples which I'm going to show here. So we have, or we don't have, such utterances served to display some evidence or to display the lack of evidence. And the purpose was to persuade the jury to display a kind of knowledge for the benefit of a jury. So the discourse was designed with the third party addressee in mind. Yeah. An interesting thing to note here are the different referential domains of the pronoun we. When you think about the previous example, we referred to all the co-present participants, to all the people present in a courtroom, whereas in this example, it's a different kind of we. We, which is used to display expert knowledge. We, which the witnesses uses to mark their solidarity with other community members, with other entomologists in this case, yeah, when they're discussing different procedures and saying, oh, we look at insects, this is what we do. This is, we look at insects, we look at what they do. We, who are we? We, the experts who are part of this expert community. And in this way, the witness marked his expert identity. So the pronoun we referred to different groups of people, right? Okay, so there are only 2 more examples on the way. Let's consider this one, which you can see right now in this slide. We're talking was among the most frequent patterns with a pronoun we. And in this case, the pronoun we refers only to the co-present participants, people who are in a courtroom, who are part of the ongoing interaction, or the here and now situation, and not to, it does not refer to the expert community, which was the case in the previous example. So when used in a courtroom, the pronoun referred to or had different reference, right? Yeah. And finally, we have reached almost the end, and that's the last excerpt and the longest one, which I would like to show to you, and just to give you some idea about the importance of hypotheticals. And as I said earlier, hypotheticals are not admissible in lay witnesses' testimony. However, since different rules apply to expert testimony, and experts are allowed to hypothesize and to consider hypothetical scenarios, this tool is frequently exploited by cross-examining attorneys, and they do it for a purpose. And here we have a longer exchange involving one such hypothetical. And this is the first line here. If we have, which, let me remind you, was one of the top, one of the most frequent clusters with a pronoun we, meaning it was quite visible in the data. The hypothetical construct is exploited to attribute some knowledge claims, again, to evoke some plausible scenarios, to refocus the testimony. And this is a string of questions, all of which aim to evoke this hypothetical, this preferred scenario. And here the attorney is trying to elicit specific response which would tie in with the master story. But then again, there is some resistance that's visible on the part of the witness, and this is what I highlighted in green, where they hedge their answer, or saying that, all right, under those facts, yes, it would, if the theory is, oh, it's analogous to some other circumstances. But then the attorney insists on selling his story and saying, I don't need analogies, I'm talking about real things. That's the situation I gave you. Wouldn't that be in this way? Would you agree with me on this? So by referring to a hypothetical situation, the attorney tries to elicit this preferred response. Right, since I have almost run out of time, I won't be able to squeeze in any more information about hypotheticals, but you just have a couple of ideas here in the slide, and if you want to, you may come back to these ideas later on. And now let me move on to the concluding part, and I'd like to share with you a couple of concluding remarks. So even though the sample which I used for this preliminary study was limited to only 4 days of testimony, certain regularities could be detected or certain patterns of interaction. And I think it's a good starting point for a more comprehensive study. So as for the eye clusters, which were the most frequent ones and which were associated with the expert witnesses' turns, these were linked to internal, that is, private frames of reference, and they were linked to explicit responsibility for the information. So this was linked to the expert witnesses discourse and how they mark their commitment to the validity of the propositions which they communicated. And these were linked to cognitive stance. As for the U and V clusters, which were subject to analysis, these types of markers were linked to external or public frames of reference accessible to all interactions. And these were linked to communicative stance and experiential stance. And the choice of markers is linked obviously to the fact that the discourse, which is producing court, and we're talking about jury trials here, is in fact designed for the third party addressee, that is the jurors. That's the actual beneficiary of this interaction, and it's more about displaying knowledge and selling a more plausible narrative, right, than anything else. So even though we deal with this dyadic exchange, the actual addressee, that's the jury. Now, as expected, a correlation was found between participant status and a type of stance that was most frequently communicated. And as for the expert witnesses, in their turns, cognitive and experiential stance markers predominated. As for the counsel, they relied on communicative and experiential stance markers. And as I said before, this kind of distinction is linked to the status they had in interaction. Two more things to be mentioned here. The most common disclaimer of knowledge, that is, I don't know, was linked to different states of knowledge. So its role was not primarily to communicate no knowledge, but it also served other purposes. Other negative polarity assessments, and here I mean those with belief verbs, they signaled either non-commitment or contrary opinions. So their functions were different. And finally, and we're almost reaching the end, as for the method of analysis, when you think about analyzing subjective meanings, when you think about analyzing stance, automated analysis, corpus analysis may be a good starting point, point of departure for a more detailed contextual analysis, but it's not an ideal tool for analyzing different layers of expression. And what I mean here is that automated analysis focuses primarily on the most frequent lexicogrammatical patterns, and other things may be overlooked. For instance, knowledge claims which are zero marked. Another thing to mention are nonverbal aspects of epistemic assessments. And as I said before, stance marking is multimodal. So if the analyst focuses on these most frequent lexicogrammatical patterns only, this is insufficient. It does not provide a full picture of how stance is marked and how the subjective meanings are negotiated. However, on a more optimistic note, despite the limitations which I have just mentioned, the corpus-assisted approach to courtroom data, and I mean, this written representation of Wandsworth discourse, it is useful. It helps to identify these access points or points of entry into the discourse of a participants, into the testimony styles and the types of stances which are adopted by the participants. So it's a good starting point for a more detailed, for a more granular analysis of certain strategies in context. And so this is all for me. Thank you very much for your attention. If you have any questions, then I'll be happy to take them. Thank you.
Thank you very much, Magda. That was fascinating. We've got about 10 minutes for questions, I believe. Yeah, any questions, if you could just raise your arm, and then if you could just switch your microphone and possibly camera on as well when asking the question, that'd be great. So yeah, any comments or questions? We need some time for the content and the conclusions to sink in, I guess. So let me start with a question, Magda. So you found a correlation there, obviously, between the status of the participant and the markers and the stance markers, and claims to knowledge markers. And I was wondering whether I'm not sure about this particular trial, but your research in general. Did you find, or do you think there is a correlation between knowledge claims markers and, one, the field of science, and two, the experience of the expert? So, are certain fields of science more amenable to stronger claims, and are more experienced experts more certain of what they've got to say, or does it not work that way? What do you think?
Possibly, right? But all I can do right now is speculate with no hard data. So I would expect more experienced expert witnesses to convey a greater degree of certainty. Yeah. But again, as I'm saying, you would need to have a larger corpus, and you would need to have expert witnesses representing different domains, forensic linguists included. Yeah, and that would be an interesting study if you compared it with hard sciences, for instance. Yeah, the kind of practices or conventions which are observed within a given domain. Yeah, how you move the idea from the source to the audience. What happens in a way. How you package the knowledge which you have, if you know what I mean, the kind of packaging you would use to communicate scientific knowledge. So yes, I would expect to find differences, but at this point, I don't have enough data to corroborate this, right? Well, what I showed here was just a preliminary study, only 4 days. Right now, I'm working on a different trial, and that's California versus Conrad Murray trial, Michael Jackson's physician, right? And here the field of medicine is important, and medical experts, cardiologists, a pharmacokinetics expert, a sleep expert, and I'm going to I hope to have more tangible conclusions here when I analyze more data and all the days of their testimony here. Yeah.
Brilliant, thank you. So, questions or comments? We've got a question from Jill. Jill, do you want to use your camera and unmute yourself? Thanks. So we can't see you, Jill, and we can't hear you, so there might be a problem with your mic.
Hello, can you hear
Yeah,
me
that
now?
works now. Yeah.
Yeah.
Brilliant. Sorry, my camera's not working, but no, I was just wondering, had you looked at the case of Michael Peterson, the documentary about that case, the Stir case? There was an expert witness at his first trial, Dwayne Deaver, who gave blood splatter analysis and made various claims about his expertise. But then it later turned out that he wasn't quite as qualified as he was trying to make out to the court. I was just kind of thinking it might be interesting looking at the responses he gave, given the fact that he wasn't as qualified as he was trying to come across to the court. I thought that might be an interesting case
All
to
right,
look
yeah,
at.
yeah. Thank you for this comment. I don't know this material, so if you could write something in the chat box, a reference or something that could lead me to the data, really appreciate that. Yeah, this is another point which you raised here. I mean, one thing is having the expertise, another thing is being able to sell it in a confident manner. So you can imagine a situation where you have an expert witness whose expertise is not reliable, but at the same time, they can be quite confident when you think about the strategies which they employ, right? But they don't need to go hand in hand, their level of expertise and their linguistic behavior. But added to this is also their nonverbal communication. And as non-verbal communication experts say, body language doesn't lie. So on the one hand, you may be trying to convey greater certainty, but at the same time, I mean, speech and gesture are co-expressive, yeah? So when you analyze this linguistic level with the expert's body language, some discrepancies may be found there. Right. Yeah, but obviously, you need data to be able to substantiate this kind of claim. Right?
Okay, thank you.
Thank you.
Thanks, Jill. And Tim?
Hi there. Hi. My question, I think, sort of follows on from both those questions from Jill and Christoph, which is, and I was thinking of yet another context in which you could apply this, which might be a contrast between the British and American adversarial systems, because in the UK at the moment, the required role of the expert witness is rapidly evolving to be much more. There's much more enforcement of the idea that they shouldn't be adversarial, that they should be the friend of the court, and as such you might expect greater expressions of uncertainty or balance or something in their evidence. So this is speculation, as you've said. I guess what my question is, do you think that you could see you developing from your observations some kind of measure of degree of certainty, or maybe degree of certainty across different dimensions, which could then be applied to all these?
Love to do that, but yeah, it takes a lot of work. Yeah, so I'll be working towards this end. Yeah, and I'm going to analyze the whole trial right now, because I'm working on a book where I'll be looking at these issues. Yeah, language and science and the interplay of these two. Yeah, but again, how do you measure certainty?
Yeah.
What can you analyze? A certain surface representation. How do you know what the speaker thinks? How do you know what they actually know? What you can analyze is just this linguistic manifestation, right? And they can lie, obviously. They can come across as confident speakers. They can be trained to communicate more certainty. Yeah. So it's kind of challenging.
Yeah, I guess what I'm thinking. So I absolutely accept that, and certainty or confidence is very distinct from competence and truth, things like that. So I guess what I was thinking. So how does it aid these comparisons? You can compare expert A to expert B, or compare the British to the American, or look at these kind of comparisons, and it doesn't have to be a scale measure, but it could provide some descriptive comparative framework.
Yeah, and I would expect to find differences as well in a civil law system. When I think about the Polish context, for instance, where expert witnesses are not retained by the parties, right, by the court.
Yeah.
So they may be expected to be more objective. Yeah. if you know what I mean. Mm-hmm.
Thank you. It's really interesting talk.
Okay. I once found this quote somewhere, an expert saying that an expert witness's role is actually to protect the truth from both attorneys, from both sides, right? If they want a scientific truth to come out and not just the admissible truth, the legal truth, which is a different thing, as we all know, right?
Which brings us to the question of what truth is, but that's a
That's
different seminar.
Yeah.
Right. We've got a question from Susan Jones. Susan.
Hi. Okay, can you hear me?
We can hear you, yes.
Okay, right. So just to let you know, my stuff is not around legal. My stuff is around linguistics in terms of being part of communities or shaping identities. And I'm really one of the reasons I wanted to be part of your talk was the idea of the idea of the expert. So I'm looking at some work I did a few years back when just people who didn't vote in the UK general election, but then did vote in the EU referendum. And exactly the stuff that you're talking about in terms of the clustering around I, we, and they. But the linguistic tool of I don't know and then I don't understand. And it's a slightly different one in terms of the expertise that is drawn on there, of how people use specific expertise of experience, specific expertise of, and then will draw back. And I just wanted to draw you a little bit on in terms on these are performances that people are giving to within that setting, and that idea of expertise. Who would they? How does the language work in terms of who they're talking to? Because that's one of the things I've got going on in some of my work in terms of being part of communities and how you identify with certain communities at the moment. I know it might be a bit out of field, but I'm absolutely fascinated by the stuff that you're doing. So, who are they presenting expertise to? Does that make sense? Sorry.
Thank you.
Right. Any other questions or comments? I think we have time for one quick question. So, Jill, your hand's up, but is it from your previous question, or do you have another question?
I'm sorry. Was there no response to that in terms of when you're presenting as expertise? How does the discourse? How does the language change in terms of presenting? Sorry, was that not?
Could you rephrase your question, please? Because I'm not sure if I'm not quite sure what you mean or what you're asking about. Right?
Yes, sorry, I have come in left field.
Well, now I can hear much better, but earlier on I couldn't make out all the words that you were saying. Sorry.
It's the idea of when of experts in a situation when within the discourse, when does it change to who are they presenting their expertise to? The person who is questioning them, or to the group? That was my question.
Mm-hmm. So if I understand you correctly, it is about how they envisage the audience and how the strategies, how their expert performance changes depending on the kind of audience they have in mind. Well, in a courtroom setting, even though you have this dyadic exchange, right? The actual addressee, that's the jury. And this expertise or is a kind of performance which is done for the benefit of the jury. So you're displaying your expertise and your skills.
That was exactly my question. Is that the jury do not have that level of expertise. So who are they?
They don't, and this is another controversial issue, whether they are competent or not. First of all, to assess the scientific knowledge that the expert communicates, and then to assess the reliability of the expert, to analyze the strategies they employ. Right? It has been argued that the jurors are not competent enough to make these assessments. Yeah.
Yeah.
But anyway, this is the intended audience.
Yeah. So that was my question. Thank you.
Sure.
Thank you, Susan. And I'm afraid we have to wrap up. So thanks very much, Magdalena, for a very interesting talk.
Thank you.
And just thank you for your time, and thank you to all the participants, and thank you for your questions. Just to say, this has been the last in our research seminar series this term. Our next online meetings are going to be in September, when we will be running the 15th edition of the conference of the International Association of Forensic Linguists. So that's from the 13th to the 15th of September. And it's going to be online on a custom-made platform. We will be providing the relevant information on our website any day soon. So check the web page if you'd like to attend the conference. That's it. Thanks very much, everyone. And we will resume the seminar series in October. So I hope to see many of you back then. Thanks very much.
Thank you again.
And thanks, Magda. Bye.
Thank you. Bye.